This is actually the last time I'm going to speak to you this period of time. It'll be the last time I get to speak to you. And it's very important for you to understand how this works. So how this works is the state attorney goes first and says their closing argument to some point. And then the defense, me, gets up and we do our entire closing argument. This is going to be our whole time. This is the last time I get to say something to you. Then the state attorney gets back up and gets to say what the finish of their case is. But most of the time, they're just going to come after the stuff I'm saying. And that's fine. That's the system. That's the way it goes. Everybody knows it. But what I really implore the jury to do is we go last until this, but we don't go last. And so when you're looking at the evidence, and when you're looking and listening to what the state attorney says after we can't speak anymore, then please do this for me. Please say, does this prove anything? Does it prove anything? Not because you think it might, not because there's just a strong inference or belief you might have that Louis Toledo did all of it. You may think that, but that's not the evidence. Even if you think that, and the evidence doesn't prove that, then we're counting on you to follow the law. We're counting on it. So please ask this question. What does this prove? Why am I hearing this phone call from the jail? Yes, why am I hearing that? Well, one of the reasons you heard it was so that the prosecutor could put on there the segment about all that foul, terrible language. Because that stirred him. They argued with each other horribly. But what did it prove? Other than saying people shouldn't talk like that, especially if they're married, what did it prove? That's what he showed you as evidence of something. When you have to make the inference, and it's not based on fact, then you're doing the job of the prosecutor. They're not doing it anymore. And they're counting on that now. Because the evidence, as I started showing you, the evidence is the evidence. You only have to be convinced to a reasonable doubt. So I want to keep going with this. Just to finish. Tyshawn, what time? You saw one, if you're the state attorney, I'm the state attorney, you saw that guy, you make your own impressions of him, you do, he couldn't order Louis. On the 18th of October, these are the text messages. You heard the little thing where they were read to you. On the 18th of October, 2013, at 11:22 and 9 seconds, Yesenius Juarez, not Louis, Yesenius Juarez texted Louis and said, "You started changing with me and becoming really disrespectful to me. Ever since you started hanging with Tyshawn, it got worse." October 18th, 2013. "You started changing with me and becoming really disrespectful to me. Ever since you started hanging with Tyshawn, it got worse." That's not Louis Toledo saying that. You'll have, I guess you have all of these. Nobody brought up Tyshawn until Ms. Suarez did. So to say that this is out of the clear blue, it's not. To say, why would Tyshawn do this? Why would he lie? Well, he doesn't have anything to lose. Yes, he does. First of all, if he did it, he really does. Secondly, he's on probation. He says it. He says it. You watched Louis Toledo on that tape just a minute ago. Gush that out. Hey man, can't go, he just said it. Now the state wants you to think he made all that up the night before. Did it look like that? He did. I'm not saying it. Ms. Suarez said it. So let's get to the end of this. He doesn't go into the 7-Eleven parking lot. He doesn't want that. He's wearing a white shirt. On the video, as I remember, it may have been gray, but it was a white colored shirt. He goes home. What's he do? He gets his phone and he starts calling. He starts calling. He starts calling. He starts calling. Now this timeline says 8:04 to 8:07, so they've expanded what the testimony, earlier testimony was, which was that he got there around 7, but the tape says what it says. This helps the story that two people did. It gives them more time. And he doesn't want to be on camera. That's my opinion. But the evidence is he got dropped off before he was on camera. Now, having said that, Louis Toledo says that Tyshawn left for a couple of hours and then he came back and then he left again. At most 2 hours, then he left and then he came back and he was gone again. That has to be more likely than Louis Toledo doing that alone. Louis is cleaning up and Tyshawn is gone. And he's gone for a while. So if it's at 1 o'clock and he leaves sometime after that, I'm speculating now because no one knows these facts. They're not evidence. But you have to figure out how this works. In these two arrows. So if he's gone for 2 hours and he leaves in the 1 o'clock hour, he's back in the 3 o'clock hour, and then he leaves again, and he's back in the 4 to 5 o'clock hour, and then they take the cars, everybody's doing something. If it happened at 3 o'clock and he left for 2 hours, he's back at 5 o'clock and he leaves again for an hour or so, and he's back at, but he doesn't leave right away, so he's back at 5, 7-ish. They take the car, he's at the 7-Eleven at 8:04. Or the alternate theory is that the state attorney says he did it by himself. Okay, he did it by himself. He has to be done at 5:30. Shows up at his brother's house at 5:30. His brother testified way back in the beginning. What was the evidence of that? So he shows up at his brother's house. His brother says, "Come on in." "No, I don't want to come in." He's not dirty. He's not messed up. He doesn't smell like bleach. That's the way the testimony of it. Come on in, it's 5:30. Or 5, or 5:08, or whatever it is. But there's nothing about that. You can believe if he had been, you'd have heard him. But there's no evidence that he was like that. Now he's just been by himself. He's just murdered his wife and 2 kids. He's disposed of the body. He's cleaned the entire house. He's bagged up everything, except what he's going to take with Tyshawn on this timeline at 6/11. But he's at his brother's house and nothing. That's evidence. That's evidence. I don't know what the state attorney will say about that when I sit down. That's the evidence. How does it change? What does that show? Does it show that he did it alone? That's the theory. That he did it alone. And not only did he do it alone, but once he got caught, he laid in that jail and thought of this incredible plan. He's the best driver ever because he did it alone. And he got to wherever he was going, and he did what he had to do, and he got back. He's the best driver ever. And he's the best cleaner of houses ever. Because he did it alone. He got all of that done. He took those bodies away. He had time to do all of that alone. That simply is not the evidence. It doesn't even fit. It can't. If you give him 4.5 hours, which means he died, they started to die at 1:04, and he shows up at his brother's at 5:30, that's the maximum amount of time. The testimony is 3, so that means he did all of that in 2.5 hours by himself. He never had a chance to do anything else because he got arrested. He got arrested. So now, here's another red herring for you. So, there's a letter from the jail. It says, we mailed 3 packages to Mexico and Arizona. What does that even mean? What does that mean? And when did you do that? By the way. He got arrested on October 23rd, 2013. When did he go to the post office? What does that even mean? But it's sitting out here, another thing to talk about, I suppose. What did it prove? What does it prove? Well, there's no evidence of what it proves. It proves that he wrote a letter. But you get to hear it. It's hard to comment on because you go, okay, somebody died. Did that show premeditation? Did that show who died? Doesn't show anything. It's another red herring. It's another in a million facts that don't mean anything in this case. Because the only facts that have to matter right now are what the state says its theory is. And the state's theory is he did it alone. And he did it in these 2 arrows. And if he didn't, then they're wrong. And if they can't prove it, then you can't convict them. And if they can't show it, they can't prove it. And because they say it doesn't mean they proved it. So that's where we are. So now Tyshawn is home. And he sees Miss Perez. He sees Miss Perez. Miss Perez is worried. And she comes over to him and says, have you seen Louis Toledo? And he says, no. He says, no. Why say no? Well, because Mom told him not to talk. Okay? Why say no? If all you did was get in the car and drive the car and park it and come back without knowing any of this was going to happen, why say no? No. Ms. Perez's testimony was that she asked him 3 times, and one time his mom was there. And her testimony was she couldn't remember what false thing he said, but it was false. That's my recollection of that testimony. He's not being truthful from Jump Street. Now, if that had been Louis Toledo, oh man. He would have been here in a moment. You're already hearing about the 1023 statement, and everybody knows from the moment of that time on the tape I played you on 1024, the 1023 statement from the time he got home in the middle of the night was all wrong. You already knew that. But now he's lying. Okay, he did. But Louis Toledo said what happened. Tyshawn Jackson didn't say what happened. He said no. Now, he says, he calls. There are all these calls. He got his phone now. All these calls to his mom, just don't talk to anybody until I get, why? Okay, she's being a mom. Fine. But then he does talk. They go and get the police. But before that, the police come over there to Kansas in the neighborhood, and he says no again. And now they do get to talk. He brings the police come to his house, and they have an interview with him at the kitchen table. What does he do? He says, then we went to this. No, he doesn't say that. He says, we went, I dropped off the car. He said, I snapped, and we came home. He doesn't tell the truth then. He doesn't. Now he's talking to the police with his mom in his house. Oh, he didn't want to talk to Louis. He's in his house. He didn't want to talk to Louis. He's in his house with his mom, with the police. And he still doesn't tell the truth. He goes to school, and this is what the state attorney just said to you. He went to school and heard a news report. This is what Mr. Johnson said. And that is when the gravity of this situation landed on Tyshawn Jackson. He knew he had to come home and tell the rest of the story. That's what Mr. Johnson just said. What are you telling me? Tyshawn Jackson said he snapped. He said he was wiping his car down and they disposed of evidence. And now it's the news report that makes it. He now realizes how bad this is. That's not believable. That's just not believable. And that's the evidence. And that's Mr. Johnson's theory. So now he's here. And now he says, I've got more to tell you. So now they put him in the car and they drive. And he's driving. He's showing where everything is. And that brings us to why he got called back yesterday. Tyshawn Jackson says what Louis Toledo's wearing. Black boots, black shirt, black. In the dumpster. Remember the evidence technician Mefford said he had to go, they had to get in there and he went in that dumpster. It was awful. Remember? It was one of the worst dumpsters he'd ever been in, and he goes in there and he's finding this bag and the trunk now. He's finding it. And now they come back out to Tyshawn Jackson, and the police ask him, what was he wearing? Black shirt, black shoes, or Timberland boots. Black shirt, black pants, Timberland boots. Are you sure? Yeah. That's what you wear. You wear it home? Yeah, you wore it home. Well, how come it's in this dumpster? How come that stuff you just said is in this dumpster? I don't know, he must have come back and changed. That's impossible. He couldn't have. Because it's buried at the bottom. It's packed down. How is that? How is that telling the truth? He got caught. He got caught. That's the evidence. But they decided that he didn't have anything to do with it. He lied over and over. He has doled out the story in pieces. I would submit this is my theory. He's doling it out because he doesn't want to get in trouble. So he says a little bit, and then the dust settles, and then he says a little bit more, and he's talking to his mom, and now they're not going to get in trouble. Because now they know they've arrested Lewis. He's doling it out. There's no doubt he doled it out. My theory is he was making sure he wasn't going to get in trouble. That's my theory. That's me speculating. But I think my theory matches more of the evidence than the state attorney's. There had to be two people. There has to be two people to fit these two arrows. He gets arrested. Louis Toledo's arrested. He's saying stuff. And he's saying more stuff. Overriding this whole thing is this question and answer. Is there any evidence to show Louis Toledo killed his children? No. That's always there. No. What do you mean circumstantially? So, okay, yeah, there is. What's that? That he killed everyone. What evidence? I'm sure you'll find out when I sit down. But now that's the state attorney saying it. It's not the testimony. And so when they throw a million facts at you, you have to say, what would I say about it? And what does it prove? What does it prove? Mr. Johnson said that if you think, I want to say this right, if there was any evidence, if there was ever any evidence that showed Louis Toledo killed his children, it's this. I think I said it right. I think it's the same point though. And then he popped it on his PowerPoint, big letters. I'll never tell you where the bodies are. Remember that? So now I'm saying, okay, but remember the testimony. That's now Detective Sheps. Remember, he's here and he's the one. This is the day that Louis tried to kill himself. So let's go back to that for a second. First of all, remember his affect. Sergeant Pagliari didn't think he was depressed. He told you that. He also didn't think he was sobbing. But you saw what you saw. So that's up to you. I would say you look depressed. You could barely hear him on that recording in this sound system. He says he wants to go to the bathroom. They take him to the bathroom. Now, this is how I remember the testimony. You remember how you remember it. Do you remember Sergeant Pagliari saying it's an L? Basically, it's an L. Now, they didn't describe the L. They didn't do that. But it's the L. So, I don't know where the bathroom is in the L. I don't know where it is. But it's an L. Okay? I don't know if the bathroom's here. I don't know if it's here. I don't know if it's in the L. I don't think it is because Detective Pagliari said he was standing in the elbow of the L. That's my memory. So I don't think the bathroom is there. Is it here? Is it here? I kind of got the impression it was at the end of one of these points on the L, but it was an L. Detective Ford says he was wherever this was. Let's pretend it's here. Detective Ford says he was 6 feet away. He was 6 feet away from Detective Sheps, who was kneeling in front of the door, talking to Louis Toledo, who was in the bathroom. Right? This is not when he tried to commit suicide. This is when he supposedly said, "I'll never tell where the bodies are." Okay? So we're on the same one. Detective Sheps is kneeling in front of the door, and Louis Toledo is in the bathroom 3 feet away from Detective Sheps. So he's 3 feet in here. Okay? So 3 feet in the door. Detective Ford said, my memory of the testimony is that Detective Ford said Louis couldn't see him, and he was 6 feet away from Sheps. And my partner even said, "You didn't measure, did you?" And he went, "Yeah, actually I did." Remember that? So he did. He measured. He's 6 feet from Sheps. I don't know if he's 6 feet, 6 feet. Louis can't see him, so it's got to be at some angle. But he's 6 feet away. And then they kind of left it like that, like he would be 6 feet away, not 6 feet away, 9 feet away. Because Louis is 3 feet in the door. Okay? And he's kneeled out in front of the door. Louis Toledo tells Detective Sheps, Sergeant Sheps, Detective Sheps, Investigator Sheps, "Are you recording me?" "Yeah, throw the recorder away." Now, you can barely hear Louis Toledo in a perfect sound system. He has asked for the recorder to be thrown away. He does not want to be recorded. Do you think he's talking in a normal voice? He's already not talking in a normal voice. Do you think he's speaking normally? I want you to help me kill us. Can you even hear me? Maybe he was speaking in a normal voice. There's no testimony about it, but what you can see is he's not. He's not. Detective Ford said he heard him. Detective Sheps said, "I'm never going to tell you where the body is." Okay? That's the second biggest piece of evidence, besides I snap. It's not recorded, again. So, you bring him back in the room, and you got him on recording, and Detective Sheps is the only one in there, and he starts talking to him about what they talked about, doesn't he? "Louis, you put me in a bad spot. Why would you want me to kill you at your house? I'm not going to help you." Basically, I'm not saying this verbatim, but the thought is, I'm not going to help you commit suicide. Because that's what he asked him to do, and that's what he said. So he documents that on the tape. He does not document that sentence, which came up to you in Technicolor, because it's so important. "I'm not going to tell you where the bodies are." Nobody says it to him. In fact, he says the opposite. He says the opposite. "Louis, is there anything you're not telling us?" "What? I thought he just told you. He's never going to tell you where the bodies are." That's not what he says. He doesn't even act like that was said. He's on tape too. This detective doesn't come in and go, "I heard you too, Louis. Why won't you tell us where the bodies are? This is important. They said Detective Pagliari knew. He didn't talk like that. He wants to know, if I call Jackie, is she going to help? Are you going to tell her? He doesn't say, Lewis, why are you going to tell us where the bodies are? You just said that. Why would you say that? That's terrible. They don't even act like that. You can watch it. I'm not saying it. This evidence is so important. This prosecutor told you, if you ever needed any evidence, any proof that he killed somebody, this is it. He's in the room by himself with Louis Toledo. By then, they have been together for days, for hours and hours and hours. It's Kurt and AJ. Come on. That giant piece of evidence, and I asked, not the state attorney, he didn't ask, I asked, why isn't that on there? And Detective Shep says, I alluded to it. I alluded to it. These guys don't allude to anything when it comes to proof. They know their job. They know their job. They didn't allude to that knife. They didn't allude to the pictures they put in front of him. They put the pictures in front of him. They put the knife in front of him. They put stuff in front of him. They asked him direct questions. This doesn't make sense. Detective Pagliari says, I'm a straight shooter, I'm going to be straight with you. I believe he was. I don't believe he knew. I don't believe it. The evidence is nobody confronted him on the recording. Why take the recording? Why have it? That's a lack of evidence, or it's a conflict in the evidence, or it's the evidence itself. That's a reasonable doubt. That's not right. If it's that important, it didn't get documented, and they had the chance to do it. They had plenty of chance to do it. He had plenty of chance to talk about that suicide, because you know why? Because they talked about it. That had it. He documented it. Now they're not. That doesn't add up. It's the most important piece, apparently. So the two things that actually go to direct evidence, not recorded, and given to you and presented to you sideways. Tashawn says he snapped. If you believe that, then it's not first-degree murder. It can't be. It can't be. Here's another point that we spent a lot of time on this in this trial. Louis Toledo leaves his mother-in-law's house and says he goes home. Now you have all these texts or messages from Ms. Suarez going, where are you? I'm here, you're not here. Okay. What is that proof? So what? It doesn't change one thing. I'm here, you're not here. Well, he said he was going home, he didn't go home. Okay. So what? If the state attorney doesn't tell you what element that proves, then it's just sitting there. It's a letter about Mexico. It's a knife that has nothing to do with anything. We have so much of that it would take me as long as the trial to go through all of it. I'm not going to do that. But I am going to ask you, implore you, that when I sit down and they flood you with this stuff, please ask two things. What does it prove? They have to tell you. They can't ask you the question, Why do you have them? They can't ask you the question. They have to tell you the proof. They have to tell you. That good prosecutor stood up here in his opening statement and said, "It is my honor to present this case to you." Then present it. Present it. They have to tell you the proof. You don't have to figure it out. They have to tell you. And now we're doing something that's incredibly important. And I want to show you the jury instruction on it. My computer went to sleep. I hope you don't. Turn the screen on, please. First of all, I just want to show you that this is a PowerPoint. This is the verdict form. And the PowerPoint you saw wasn't the verdict form. It was a sales presentation, where he clicked all the boxes and said guilty. This is the verdict form that you'll get from the judge. And you'll take it in the back. Please note that not guilty is on, and that lesser included offenses are on. Not just the top box that in the PowerPoint business presentation. I'm not trying to sell you. This is the actual verdict. So you'll get a chance to see that. And then this is the jury instructions. And judge, this is what you'll get when you go back. And there's a whole bunch of stuff on here, but I want to go to one part of it. This part right here. Single defendant, multiple counts. A separate crime is charged in each indictment. And although they've been tried together, each crime and the evidence applicable to it must be considered separate. And a separate verdict returned as to each. A finding of guilty or not guilty as to one crime. This is so important. A finding of guilty or not guilty as to one crime must not affect your verdict as to the crimes charged. I'm going to submit to you, as Mr. Toledo's lawyer, you're going to hear a lot of very important instructions, but there will not be one more important than that paragraph. A separate crime is charged in each indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict return on each. If you remember in your jury selection, some of you heard my colleagues say to you, these are like mini trials all on their own. Do you remember that? But they are. Count one is count one. Count two is count two. And count three is count three. And you have to talk about each one. You can't say, yeah, it's all this. You have to talk about each one. A separate crime has been charged in each count. They stand alone. They have to take the measure of proof all on their own, and not because you found it somewhere else that applied to a different count. These counts are by themselves. They're on the same piece of paper, but they're by themselves. And this is huge. This is very important. Here's why it's important. You don't know how those children were killed. And you don't know when they were killed. And you don't know how they were killed. You don't know any of that. The detective said that. Now, if you believe Louis Toledo, then Tyshawn Jackson killed those children. The The state wants you to say, no, that was Louis Toledo. That's not the evidence, and the detective told you they don't have any evidence. So now you have to take these counts separately. And here's the problem. I understood the state attorney when he was up here. The circumstances under which the children were killed make it first-degree murder. Well, what are the circumstances? You don't know, because there's no evidence of any circumstance. Mr. Johnson said that Louis Toledo, this is what Mr. Johnson said to you in this morning. Louis Toledo struck his wife. The kids probably came running out, said, who died? Mommy, wherever it was, he said. And that's when Louis Toledo knew he had to kill his kids because they were witnesses. That's what Mr. Johnson said. There is literally no evidence of that. That's Mr. Johnson's argument. That's his opinion. He and I can give our opinion, and it's not evidence. So there's no evidence of that at all. The evidence is Tyshawn did it, or you don't know. Because I'm going to tell you right now, if Detective Pagliari knew, he would have told you. If Leroy Parker would have known, he would have told you. If Detective Ford would have known, he would tell you. And you don't know, because they didn't tell you. And Mr. Johnson can't tell you. And so why am I saying this instruction? Because you don't know the circumstances. And if the circumstances are argued to you that he snapped with one, but he had two and a half, it has to be first-degree murder on the other one. If that's the premise, then they have to tell you which one. Because each crime is charged separately. Each crime has to be considered separately. That's the law. You're going to get that back there. So you don't infer which one. You don't do that. That's their job. When you begin to infer, then you're doing the job for it. So they have to tell you which one, and you don't know which one. You don't. If the theory is Louis Toledo did this by himself, you don't know, because they didn't tell you. There's no testimony, there's no evidence. And because they say something circumstantial, it has to be a fact, not an inference. Why did he throw the knife? Okay, why? What's the circumstance? And if the circumstance even makes sense to you, you go, Jeff, that makes sense. That makes sense. One of them had to be one of them. That makes sense. What you believe, you're allowed to believe. You're just not allowed to do it on a verdict. You can think it. But that's not the law. Because they have to prove this to you, even if you think it. They have to prove it to you. And they have to prove it to you separately. So they have to tell you which one. You don't pick, okay, we'll pick this one. It must have been Talia, because she came out and said, you don't know that. Here's what else you don't know. You don't know if they were all together when it happened. You don't even know that. Because if he snapped and they were all together, and you think he did, then he snapped. He didn't think about it and do it, then he did it. But you don't know if they were all together. You don't know if, I'm not trying to be flip about this, but you don't know if he was trying to do something with his wife to help her and somehow something happened. that was an accident. You don't know that. You don't know the circumstances. And you're not the one that picks who went first. That's not the law, and that's the law. So if they don't tell you, then you don't know the answer. And there's no evidence to tell you, unless you believe Louis Toledo. Then he didn't do it. I should. So that's the law. That's the law, and that is so important for you to consider. Please consider. Read it. When you look at count one, you have to say, I think count one is Michael. Did Michael die? Was it Michael? Was it premeditated? Louis Toledo thought about killing Michael when he did, even if it was a short time. He had a fully formed, conscious intent to kill Michael. What's the evidence of that? Second, do you have any evidence Louis Toledo killed his kids? No. If they knew, we wouldn't be talking about it. You'd know. You really know. And it wouldn't require me to sit down for the prosecutor to get up and tell you when I can't talk. You just know. It's not there. And you can't choose. Count two is Toledo. What's the evidence? Who went first? If the scenario is, the circumstances say it had to be premeditated murder. And for at least one of them, Jeff, which one? They have to tell you. Because these are separate crimes. They have to tell you. And they're not going to tell you. And if they do tell you, where did that come from? And what does it prove? Now, there are lesser included offenses on this verdict form that I showed you. And when the judge gives you the jury instructions, he's going to talk to you about lesser included offenses. I want to talk to you about two of them. And I'm going to talk to you about them in the way that it is for all three people. This is the instruction for manslaughter on Ms. Suarez. There is a manslaughter lesser included offense for first degree murder, but it's called aggravated manslaughter. And that's on there too. The reason it's aggravated manslaughter for first degree murder is, in this case, is because they were children. So that bumps up. And Louis is a caregiver. So that makes it more than simple manslaughter. In Florida, we call it aggravated manslaughter. But there's manslaughter. And the gist of manslaughter is that he intentionally committed an act or acts that caused the death of Yesenia Suarez or the children. And it was caused by culpable negligence. In other words, he was grossly, awfully, illegally negligent. If you believe, I'm going to just submit this to you. You heard Louis Toledo say, she grabbed me, you just saw it. She grabbed me, and I'm going to submit to you this theory. If you believe Louis Toledo acted, if you believe he acted, then he acted negligently. If you believe he reacted, that's manslaughter. If you believe he reacted, if you believe he acted, then you have to determine, in Ms. Suarez's case, what that was. Was it because he acted with a depraved mind? Is that what he did? To make it second-degree murder? If he snapped and he acted, then you have to consider the crimes. But then you have to say, why did he act? Did he act with a depraved mind? But if you think he reacted, and he reacted in a way that he reacted in a way that each of us has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intent to harm, he reacted. That violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had the intent to cause death. He reacted. If you believe he acted, then you have to determine if he acted with a depraved mind. It's the same thing for the children. Here's the problem you have with the children. You don't know what happened. You don't know any of the elements. There's no evidence that Toledo thought about killing his kids and he did it. There's just not. And that's an element. And when you can't find that element, you have to go to the next crime. Now, did Toledo commit second-degree murder? Did he? With the children. What's the evidence of that? Because the evidence is there is no evidence. You can't make up the circumstances for them, even if he asks you to, even if you think it. Jeff, kids die. Jeff, adults. We're counting on you to follow the law. We're counting on you. You get an oath that you would do that. This judge is going to tell you this instruction. He's going to say to you, rule for deliberation. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending on it to make wise legal decisions. This case must be decided upon the evidence that you have heard from the testimonies of witnesses and have seen in the form of exhibits and evidence and these instructions. This case must not be decided for or against anyone because you are sorry for them, or you feel sorry for them, or you're angry at anyone. By now, I should tell you, the lawyers are not on trial. Your verdict should not be influenced by feelings of prejudice, or bias, or sympathy. Your verdict must be based on the evidence and the law contained in the instructions. That's what I told you. You get to have those feelings. You get to have them. You just can't base your verdict on it at all. You just can't do it. You can't do it. charges are argued to you from the state's point of view in a different way, really kind of a weird way. Because we spent a lot of time talking about why Louis Toledo is mad, and that's motive. But motive is an intent, and you have to decide intent. Motive isn't an element. Why he had the intent is not an element. Quite frankly, they don't have to show them. They don't have to show them. That's the law. But they've done it. They think they've done it. Louis Toledo, they say, had a motive. He had a motive. He was so mad about this marriage falling apart, and so mad about this affair. He had a motive. Motive is not intent. Motive is what causes or doesn't cause intent. Intent is intent. And the intent required in first-degree murder is that he committed an intentional act, premeditation, thought about it, and he did it because he intended to do it. Not that he had a motive to do it. So when you get this evidence thrown at you that says he was so mad at his wife, she's not charged with first-degree murder. The motive is not relevant. It is the cause, maybe that affair and that marriage. It's kind of so embarrassing, some of it, to read these text messages. But you know what? There was one in Spanish. We bring out. Leave me in peace. They don't say that. They just said it was in Spanish. He said that. I don't want a divorce. He said that. Leave me in peace. Even the motive. Okay, they were there. That's it. But this motive thing about second-degree murder, that's sideways. The motive has to be an intentional act, not a snap. If he snapped, that's not first-degree murder. And the motive now that they say for first-degree murder is that those kids witnessed the murder and they need to be eliminated. So when you hear all of the stuff about the affair, that's not relevant because it applies. There's no motive for second-degree murder. He acted in a depraved mind because he was upset. He acted in a depraved mind. Did he? Or did he react? In the millionth argument, in the millionth hour of the disintegrating marriage, did he react? This is how they argued. They were physical. They were vulgar sometimes. They hurt each other a lot. This is how they argued. Okay, that's it. Did he act or did he react? And then when you get to these children, the motive is, according to the state, they need to be eliminated. Where is the evidence of that? The evidence of that is that Tyshawn killed him and said that. That's the evidence. But they want you to substitute Lewis onto that. But how do you do that? Because you don't know how they died. You don't know when they died. You don't know who was there when they died. You don't know anything about how they died. And when the state says we're willing to accept Mr. Toledo's version of the events, well, they're not. They're not accepting Mr. Toledo's version of the events because Mr. Toledo's version of the events has been the same since 2013. Tyshawn Jackson killed my kids. I don't know where they're at. What if he really doesn't know where they're at? Think about that for 5 seconds. He has confessed to the whole thing. What is the point, if he knows, of not saying it? He told them where the vacuum cleaner was. He told them everything. What if he really doesn't know? And when he tried to commit suicide, he didn't scream out, "I'm never telling you." He screamed out, "I don't know."
We need to take a break.
I'm almost done. I'm almost done. I don't know. I don't know. Let me die. What if he really doesn't know? He says he doesn't know. He's always said. What is the point of this? I'm asking. They have to tell you. If it's circumstantial evidence, then they have to tell you what fact that comes from. You can't infer it. Because the evidence is that he says he doesn't know and he's never wavered. So that's our case. It's our case. It's been a long case. We're counting on you to follow the law. The law is very clear. The facts are not so simple. There's very much there that you have to consider. You know the game we're playing. You know what's at stake. We're counting on you to follow the law. This process has to matter more than your opinion. It has to matter more than your personal feelings. It has to matter more than what you think. This process has to matter. We don't have a process. We're counting on you to follow the law on behalf of my colleagues and Mr. Lewis Toledo. Thank you for your service. Thank you very much.
Thank you. We'll take another 15 minutes.